resume. All right, well, welcome everyone. I'm really delighted to have speakers here to tell you about plaintiff side civil litigation. And you'll see from the speakers' descriptions of what they do that what they do is actually pretty different depending on their particular practice. But they all represent plaintiffs. So I think I'll start. Why don't we start with Brittany and Scott? Can you tell me a little bit about what you guys do, what your day-to-day life is like, and how you got to where you are?
Sure. Thank you, Scott. So we have Brittany and I are lawyers in a very small personal injury, products liability, medical malpractice plaintiff's firm. We do exclusively contingent fee work. We don't bill at all. We eat what we kill, basically. And everything that we do is discussed between us and thought about and evaluated, and we're pretty careful with the work that we take, and we've had remarkable results over the years. So it came about. I doubt anybody goes to law school thinking I want to be a personal injury lawyer when I grow up. It's kind of not one of those kind of subsets of the practice that you think that's what you want to do. But I kind of fell into it. I was doing plaintiff's antitrust when I first got out of law school. I thought of myself as a public interest guy, and thinking plaintiff's antitrust was the way to go, and frankly got frustrated with the level of document involvement and paper pushing that was in that business. And a classmate of mine at Hastings actually was working for a small boutique firm here in San Francisco at the time. And he pulled me in there, and I never looked back. I was a partner with a small firm for about 10 years, and then 1992 started this practice. And Brittany joined me about 8 years ago, and we've never looked back. So we pick cases against some really high-end defendants, the HPs of the world, the Harley Davidsons of the world, the some pretty significant defendants that we work against. And we do we do a lot of personal injury stuff, but we also do some complicated products work and quite a bit of complicated malpractice work, medical malpractice work as well. I would say the practice is something that I've really grown to love over the years. It wasn't something that I ever thought that I was going to be attracted to, but there's some incredible and wonderful things about it. Not the least of which is that the results that we get for our clients are great. The pleasure and joy of pulling somebody who's really in a bad spot out of that spot, and changing their lives, turning things around for them is a wonderful experience. And the win-win of the business that we're in is something that's a real draw, and that I think both Brittany and I are really attracted to. In addition, there's a wonderful community of lawyers that do what we do. And so that also is a plus, because there's a lot of support in the San Francisco Bay Area community for lawyers that do what we do. And, it helps everybody flourish. It's, a high tide raises all boats, as they say. And, there are very few people that won't really reach out and, work with you in the business, to give you briefs, to give you information about experts, to, do all the things that are, really critical in this business. So anyway, that's my 2 cents. And I guess I'll kick it to Brittany and see what she has to say.
Yeah, Brittany, anything to add?
Yeah, I mean, I would, of course, agree with all of that. I think that plaintiff side civil litigation, like Scott said, is not something that people necessarily think about when they're in law school. And it wasn't something that I thought about when I was in law school, but I was of a similar mind of Scott, thinking about public interest. I did some homeless advocacy and things like that when I was in law school. And I actually started working with Scott when I was in law school at Hastings and worked there as a clerk. And then upon passing the bar, became an attorney about 8 years ago, I think you're right. And it was a business that when I got into it, realized that it met a lot of those criteria that I thought were important to me and what I wanted to do with my legal practice and do with my life as somebody who has accessed higher education and been able to get out there in the world and put my part into it. So I think that it really aligned in ways, and it's also a place where you don't have to get a fellowship or, you know, take, I know student loans are a big thing for people of our generation, you know, get into some, you know, income-based or payment program that's going to end up with, you know, just capitalized debt at the end of it. You have some opportunity to be able to get out of that hole and create a bit of a life for yourself while you're still maintaining those values of being able to actually help people, because the people that we get to work with are really incredible. I mean, I will remember some of these clients for the rest of my life. You know, and I just, so many come to mind, people who are able to buy a house for their family and not have to worry about having a roof over their head. Just that alone can really change somebody's life, and we get the chance to do that. And most of the people we go up against are insurance companies. And so it's really, you know, an opportunity to get people into a position that they can be effective in their lives. And that was very important to me as part of the fabric of what I do as an attorney. So I think it was surprising somewhat to find all of those pieces in the personal injury litigation area of law. And actually, while I was in law school, while I started working for Scott, I did in a legal history class, a little research about why personal injury gets such a bad rap, because I found that people really actually get quite a bit of benefit from it, from society overall as well. So I think that it's a place where you get to use a lot of different skills as well, where you get to go to court. You get to, you know, also go over a lot of documents and read a lot of things and write a lot of things. You get to have depositions. You get to engage with people. Obviously, that's changed a little bit in these times, but I think some of the things that have come from these times, like remote hearings, will probably continue into the future, and maybe to the benefit of us all. Sometimes we have clients that are far away. Now they can just Zoom rather than have to hop on a plane and, you know, incur all of that to do. So I think it's an industry that's got some foundational principles that are really beneficial for those who want to pursue something like that, and an opportunity to really at this point be on the forefront of the legal profession overall. The courts are asking us, do we like remote hearings? What are we going to do going forward? And I think we're at the precipice of being able to sort of influence some of those things. So for all those reasons, I think it's a very engaging practice and a really great way to make your living as a lawyer. And that's my 2 cents on it.
Thank you. Let's go small to big. So next up would be Sarah. Hi, Sarah. Welcome back.
Hi, thank you. So I do employment class actions with a firm based in Emeryville, mostly wage and hour. We're doing some COVID-related health and safety cases recently, which is very interesting. What I like, and I've been in quarantine the entire time I've had this job. So before I had this job, I worked at a nonprofit for 3 years. I did eviction defense at a nonprofit in Oakland. And that was a fantastic experience. I got a lot of, I didn't end up doing a trial, but got close to doing trials, did a lot of hearings, a lot of motion practice, and that has benefited me in this job. And in this job, I really enjoy that. I loved the relationships I had with my clients in the nonprofit area because it was really one-on-one. But what I do enjoy about this job is that because we're doing class actions, we can have a wider impact with the litigation that we do. And I have more of an opportunity to do research and writing and novel cases like these these COVID cases that I mentioned. So I find that very enjoyable. And in terms of how I got here before, other than the nonprofit I worked at, I also clerked for a magistrate judge in the District of Nevada right out of law school. Then was at Centro, the nonprofit I mentioned, for 3 years, and now I've been at Schneider Wallace for about a year. So that's me.
Sarah, may I ask, do you do collective actions primarily for the wage and hour stuff, or is it true class actions?
Oh yes, that's a good question. So we do class and collective actions. We do like to use the Private Attorneys General Act because arbitration is so popular and easily enforceable, but we do both.
Great. Well, thank you. Let's go to Dina.
Thank you, Scott. And I should start by thanking you for inviting me back. It's really great to be here, and it's really a privilege to get to talk to a class of law school students who, I think, at least based on what Scott and Brittany said, you guys are doing a lot better than the three of us were, because you seem to at least have a sense of what you want to do when you get out of law school. And I know I didn't, and it sounds like Scott and Brittany kind of fell into what they did too. And so good job. You're already ahead of the game. And I also really do want to thank Professor Dodson for presenting our viewpoint, because not to trash Hastings, because I never would, but the one thing that I think Hastings didn't provide to me as much as I would have liked was a better understanding of the full options that are out there as a litigator. If you're interested in civil litigation, it's not like there's a binary choice between defending insurance companies and banks or being a nonprofit lawyer. And I think you're hearing about some of the things that can happen on the spectrum there. I can tell you that I was struggling trying to figure out what to do when I was at Hastings and thought I wanted to clerk. And then I didn't get the clerkship because I'm not that big of a academic, I guess, or whatever. My brain isn't big enough. And that turned out to be a blessing as far as I was concerned, because what I realized was I was really ready to get out there and start advocating. But I couldn't figure out quite how, because I knew only a couple things. One was that I didn't want to defend insurance companies and banks and drug companies. It just wasn't in my DNA. Another was that I have the benefit of having a couple siblings who are lawyers. So I had a sister who'd been at the DOJ for like 20 years, and I thought that was interesting, but probably not my cup of tea either, because it felt like she was stuck in a bureaucratic mess all the time. I have a brother who's a defense lawyer, and in fact, he defends class actions. We're waiting for the day that we get to do a case together. I can't.
Don't do it.
I can't wait to kick his ass, I got to tell you. But aside from that, I mean, what I'll say is that you're doing the right thing right now by actually trying to explore this and figure this out. And I truly am grateful for the chance to talk about it, because I love my job. I mean, you can ask pretty much anybody. There are a lot of lawyers who are unhappy and don't like what they do. And I get that, because there are a lot of really garbage law jobs out there. But we on the plaintiff side, or at least in my firm and in my position, I just feel incredibly privileged to get to do what I do, because I got to go to a good school like Hastings, and then I got to go forget everything I learned in law school and start over again, basically, and start a business. Because what we do and what you hear from small plaintiffs firms is that we're not just lawyers, we're doing two things, and we can't do either without the other. We have to be lawyers and we have to run a firm. And so there's a business model that's baked into what we do. And there's sort of a spirit of entrepreneurial ship, at least in the kind of in my world that I'm going to talk about in a second. But these things are pretty important. It took some time, at least for me, to figure it out. So just to give you a really quick sense of what I do and how it's a little bit different than Scott and Brittany and Sarah's practice. We do what I would call just super complex cases. And so we do, I specialize mostly in class cases. I do, some non-class matters, but largely class actions. I focus mostly on antitrust work and also on consumer work. And, the way I would describe our firm is that we're a plaintiff side boutique. We're pretty small. We have, between 12 and 15 lawyers any given time. And that fluctuates depending on the work that we have in the office. We kind of think of ourselves as private enforcers, but make no mistake, we work on contingency too. Like Scott and Brittany, we only get paid if we win or if we settle. We eat what we kill, as they say. Unlike my colleagues in the personal injury space, we do write down all our time. We bill time pretty much like corporate lawyers do. And the reason is because in our cases, unlike in personal injury cases and class actions, because those are all governed by Rule 23, we don't get to usually just kind of make it up and go file it. We have to get appointed by a court at some point usually. So we kind of work for federal judges. That's sort of the bottom line. If you want to know who I work for my clients first, and I work for federal judges. And we have to usually get appointed by the judge, and then we have to demonstrate to the judge that we're discharging our fiduciary duties under Rule 23 to go do a good job, get money for the class, and then get it distributed in a way that's equitable. And only then do we get paid. So you talk to anybody who's like in business, you know, like business school people, and you tell them what the business model is, and they tell you you're nuts because there are way too many variables, because setting aside the fact that, you know, clients bail out and judges hate us, there's almost always bad facts, there's almost always bad law. So the way I describe my job is, hey, it's easy. All we have to do is be smarter, more creative, faster, more diligent, and more interesting than our adversaries, and then we win. You know, that's all we have to do. It's not too tough. It is pretty crazy, but it is really fun. And in terms of what's great about the work, we have autonomy. And I mean that top to bottom. We run our firm in a way that's not hierarchical or bureaucratic. The question isn't, are you the most senior person? It's just, do you have the best idea? And also, can you please go do the work, because we have way, way, way too much. And we're all candidly just drinking from the fire hose at all times, pretty much. Sometimes just a little harder fire hose than others. You know, I would say that the thing that we all have in common is that we have the great good fortune of representing people, right? Sarah represents people who are having problems in their workplace. Scott and Brittany represent people who've been injured in some way wrongfully. I get to represent people who sometimes they know that they've been injured, sometimes they don't, and that's the truth. I mean, we'll have clients, we have pretty big clients who definitely know that they've been injured and come to us. But of course, one of the ideas behind class actions, as you all learned in Civ Pro, is that the idea is you take all these very small claims and you put them together, and you need somebody who identifies those issues and then goes out and brings those cases. And you know, there's a very, very strong movement in this country that's been going on for years. That's basically a tort reform movement that says, you know, you're bad and you're making it harder for businesses to do what they do. And of course, there's some truth to that. There's always truth to both sides of it. But our perspective on it is that because we work on a contingency fee basis, and because we only get paid if the judge wants to pay us, we are incentivized many times over to only bring the good meritorious cases, the ones that are really going to mean something to our clients. Because my practice isn't improved if I bring the case about a tea bag that has too few rose hips in it and somebody's upset that it didn't have the right flavor. That's not really going to improve society or advance the interests of our class. Whereas if we're going out and proving that drug companies are getting together to conspire to keep the prices of brand drugs high and to keep generic versions out of the market, now that is something that I think that most Americans would look at if they were presented with it sort of on an even keel and say, hey, that's interesting. And that's really where I think that our work is super fascinating. And again, our clients are the people who are paying that money, and not, you know, the drug companies that are putting together those schemes. And look, there's a place for everybody in the practice, but for me, this is really kind of the exciting place where we get to figure out what kind of results we can get for ordinary people, for ordinary Americans who otherwise would not have really any way to, you know, enforce or go after these companies that have wronged them. So I'll stop there, but hope that's a little bit helpful in terms of our practice.
Yeah, that was great. I have a couple of follow-ups. And I want to follow up on something that Dina mentioned, which is basically just the business side of plaintiff side firms. And so, you know, maybe Dina, we'll start with you and then I'll go back down the line. You can tell me a little bit about how much of that occupies your time, how much of that dictates the strategies that you employ in deciding to take a case or not. You know, it's not like you have institutional clients where whenever they have a problem, they run to their law firm. and the law firm just bills, and it's got tons of clients, and always has this kind of a steady stream of income. The business models that you guys have are a little bit different. So can you tell me a little bit about how that influences both your day-to-day life and also the practice in general?
Sure. So I'll unpack that a little bit and talk first about case selection, because it feeds right into how we run the business. We select our cases very, very carefully, because as you can imagine, especially in these big, like an antitrust class action, it's not over in a year. I mean, we rarely get them soup to nuts from, pre-trial or from, the first conference to trial date in less than 2 or 3 years. They are expert heavy cases. And so for us to spend $3, $4, $5 million on experts and costs alone over the course of a case is not unheard of at all. And so you get a sense that, that is a business consideration. It burns pretty bright, right? Doesn't matter if you're a lawyer or anything else. If you're putting out that kind of money, you've got to have a business plan. And so, we can't afford to pick dogs in terms of the cases. And so it basically drives everything. It's important that we pick good cases. We also need a pretty good portfolio mix. In other words, if we have only those long ball cases that take 5 years, we're going to probably end up having cash flow problems. And so we need to pick good cases, and we need to pick ones that are at a variety of levels that can be worked on by a variety of lawyers at the office, because there's only so much that we can do. So that's kind of the case selection. In terms of running the business, the truth of the matter is that I think it depends on which small firm owner you ask, because some of us mostly would prefer to just be doing the lawyering all the time. And there are admin needs of the firm. And I think I'm very fortunate, because my partner, Dan Gerard, and I have a really great collaborative relationship where we really do co-run the firm. And, he's the managing partner. He founded it. He's been running the firm for many years. And I do what I think is kind of the bare minimum to make the firm work well. I think that, we're in the business of doing good legal work, not of being a perfect small business, but we also need to obviously do enough to make sure that that all of our lawyers and staff have what they need. And so it's a balance, but at the end of the day, it's really just kind of the same as any other small business. We have a balance sheet, we have assets, we have liabilities, we do a P&L. We look at it, what we refer to it as WIP, work in progress. So all of our lawyers write down their time. Once a week, I get a report that says, here's the amount of time that the lawyers are putting into each case. Here's the expenses. And we take a look at it and try to kind of balance it out in terms of both the cases that we're bringing and the cases that we're trying to resolve. So it's very much a numbers game with the overlay of the complete uncertainty of which cases are actually going to be successful or not. So I hope that's a little bit helpful. I'm happy to kind of go through the math, but I think, it's the same equations that most small business owners have to run through. The only difference is that our inventory is attorney time in cases and not widgets of some other kind.
Yeah, that's great. Sarah, what about your firm, and how does the business model work, and especially with case selection?
So I think actually Dina covered it very well. I would say that Schneider Wallace is quite similar. We do also bill all of our time, and some of the partners are a little bit more business minded, and so they're very focused on bringing in new cases, new ideas, new strategies, and then others, including the partner that I work most closely with, are really more focused on the lawyering. But as a team, they really make it work. And I can't speak to it very much because I'm pretty insulated from having to worry about the business side as an associate. But with case selection, we do what we call new business roundtable, where people, associates or partners or anyone, can bring new ideas for types of cases we'd like to bring, and then we will end up doing kind of campaigns off of that to try to bring in new cases. And sometimes we'll see something unjust or unlawful happening more personally, and we'll get a case that way. So for example, I had a coworker there was a guy who delivered an appliance or something to her home, and it turned out that he was experiencing wage and hour violations, and a class action came out of that interaction. So it can kind of depend. But we do also have to do, I think, more targeted outreach to try to keep the business going, because at the end of the day, it is a business.
Are there, Sarah, can I follow up? Are there cases that come in your door where you're just like, you know, I got into this business because I want to help people, and this person has definitely been wronged, but we just can't take the case because it doesn't fit our business model? Are there those? And if so, how do you deal with that?
Oh, yes, absolutely. That's a really good question. So, I mean, one thing that we do look at when we get potential cases is the size of the target, because the way the firm works, if the company that we might be going after is too small, then we can't take the case. Also, sometimes it really isn't suitable for class treatment. It's much more of an individualized issue. So in those situations, I mean, I think when it's more of an individualized issue, we know private attorneys who do, and nonprofits who do individual work that we can refer people to. And with the size of the target, I mean, we might also refer them out to if that's the reason that we're not able to take the case.
Scott and Brittany, how does your business model work, and how does that influence your practice?
Well, if the question is how do we get our cases, you know, it's a bit of a combination. I would say one of my pet peeves in this business is lawyer advertising. It just makes me completely insane. You know, when I started out years ago, there was really hardly any of it. And then it evolved to, you know, an internet site. And, you know, now you hear this stuff just on television all night long, and, you know, all over the billboards, and it's insanity. And it gets a little frustrating. So, you know, and the other thing that it does that is kind of bothersome, it's like the public, you know, a lot of the public still does not understand the difference between, you know, somebody who knows what they're doing and somebody who doesn't. And all they see are these ads that you know, they really don't know what to do with. And so it's a bit of a problem. But that said, we get our cases largely from referrals. The best cases that we get come from either clients that I've worked with in the past, lawyers that know us, lawyers that I've worked with, lawyers that you know, are in the audience where I speak. You know, those kinds of sources are really where the cases come from. Once in a while, I do get some cases off the website. You know, you don't see my face on the billboard. It's just, I'm just not willing to do it. And so far, it hasn't been a problem. I mean, so far, it's already been, you know, 30 plus years of the practice. And we managed to, you know, really bring in solid cases. And as Dina said, you know, you do have to be careful about the cases that you choose. It's, you know, the biggest decision that you make in the course of any case is taking the case or not taking the case. So, you know, that's something that, you know, is just a process. You just, there comes a point where you just have to trust that the cases are going to come in. And there are those weeks and months where they don't come in and you're going, man, what's going on? And then, you know, there's a month where you're getting call after call after call and the cases are great. And, you know, that feeds what is the pipeline that goes on, you know, over the course of the life of the business. So, you know, it's a mixed process. It depends when you're in the, you know, at what point in your business model you are. You know, when you're just starting it out, it's not easy to get cases, and then you have to kind of scramble to make cases that you otherwise you might not take 10 years from now, you know, work for you to make your business work. And then, you know, as the business matures, then you can be a little more selective about the cases that you're choosing. And as it, you finally get to a place where we are, you really have your choices as to what to do. So, it's a mix. I guess that's what I'd say about it. Brittany, your thoughts?
Yeah, I think that in terms of the impact on the cases that we even do take after calls, as Scott mentioned, we do malpractice work, and that work in particular has some pretty significant limitations on the cases that we can take because there's been a cap on malpractice damages since the 70s that's never been raised for inflation. And as inflation goes up and the costs go up, the cap is 250. And the last case I got ready for trial for, the costs were that by the time we hadn't even talked to the jury yet. Just the costs of hiring experts, filing court fees, all of that, not my fees at all. So it makes it really hard to take cases for people that have been wronged, that do have a case in terms of liability, but the damages just aren't there. And in particular, it is only for what we call non-economic damages, which means that economic damages are available, which what that results in is that people who are employed get represented and are making money, but people who are disabled, who are older, the more vulnerable people in our society can't find those attorneys to represent them, even though they've actually been wronged and there is liability there. So that is one place in particular that is dear to my heart, because I have to talk to those people and tell them that I'm sorry your mother's dead, or, I'm sorry that somebody maimed your family member, but we can't help you. And so those, I think, really impact for me the cases that we do and don't take, and what, but that's particular to medical malpractice. But more generally in personal injury, you do have to evaluate cases that come in, because as everyone's mentioned, the kill what you eat sort of thing, that we have to find some line to success in that case to make it functional for the office, because we are putting up all of the money for these cases in advance. That could be 5 years that, we're spending hundreds of thousands, millions of dollars on cases and waiting, to get reimbursed. So the overall idea of the business model, as Scott sort of touched on, if you don't have something sort of coming down the pike, then you can become worried about that. And it is part of what you have to consider in this business model. There's not, some government client that's just going to pay your fees every day, or corporate client who's just going to pay your fees every day. So that's my 2 cents on how taking cases sort of works into the overall business model for us.
So I'll just ask one more question of each of you, and then I'll probably turn it over to the students. So I guess what, the last question would be, what are the trade-offs? How does this career compare in sort of quality of life, fulfillment, terms, given all the trade-offs that there are to many of the other kinds of careers that might be available to civil litigators. So I'll start with Brittany. You don't have to talk about your cranky boss or anything like that, but what are the trade-offs?
Well, that's sort of more of an easy question, because I think they're almost incomparable. My opinion is fully respected in my office. There's no, senior associate, like bureaucratic structure that someone doesn't listen to me. It is collaborative. It's creative. It's more, from what I hear from my friends, more healthy for your mental health than being judged by how many hours you have been sitting in that chair. It's judged on, you get to see your successes in real time as well. You get to participate in the process from start to finish. You get to talk to the clients whose lives these are actually impacting, and that plays significantly into your motivation for wanting to continue to represent, because the hours can get very long. It's not that long hours don't happen. They just don't happen unnecessarily. you're just not there to be there. You're there because you're working on something that requires that amount of focus, research, dedication, and thought process. And I think that that really helps stay engaged with the practice. And then being in a small firm as well, you have the benefit of interacting with things that you want for your personal life. It's not, checking the clock when I'm clocking in. And, if I want to take an extra vacation day, maybe that, if I work another day, maybe I can trade that off. It's more flexible in that manner. One thing that comes to mind in the pandemic is that we have an assistant who's single mom, and have been able to be flexible for her and make it work for her life too. So I think that those things come more quickly and are more just easier. I don't want to, talk bad about any other business models, but I think this business model lends itself to being able to have that flexibility. And I think a lot of people, even our, support staff, has said that they seek out employment in this kind of business model because it can come with that kind of flexibility. And of course, a lot of that comes from who's at the top of your firm, and I have Scott, so I'm very lucky. But I think overall that it really can help to give you a little bit of a different and a little more flexible lifestyle in terms of hours and being able to, well, back in the day, being able to go out to like a baseball game with everybody in your office. It's sort of nice to have that small community. You care about each other. So that's what I would say about the sort of trade-offs of big law versus small law, as it were.
Scott?
And so is the question, how do I feel about the practice?
Yeah, but taking into consideration some of the things you might have had to give up or give up on a daily basis to do what you love to do.
So, the last part of your comment is kind of the key for me. I do what I love to do. And I think Dina mentioned the same thing. It's like my view of this business, it's a tough business. I mean, there is no sugarcoating it. You work hard and, what you do matters. It matters to the people that you represent. It matters, I've done maybe a dozen appeals over the course of my practice, and you'll see my name all over the appellate record, sometimes for better, sometimes for worse, but largely we've had some pretty nice results. But you impact people, directly. And, for me, that's pretty motivating. So, I work super hard. Brittany will tell you that, she's probably never seen anyone work like like I work, but I do love what I do. So what I give up is, I don't think it's insignificant, really. I don't take as many vacations as I wish I did. I'm hoping to, maybe move that in a direction in the next few years and, grab a few more days and, take a little more time to travel. So with a small firm, you are, you're it. And, you can go someplace, but you got to bring your computer with you, or at least I do. And that, I think, is the biggest trade-off. But, I've managed to, raise a couple of kids, go to all their Little League games, go to all their college events, do, all the things that are super important to me in my life. And so, it's all about your list of priorities in the world. And every day that you work, that you're working or doing something, for the most part, I mean, we spend more time, working than, any place else. And I'm just saying, you better love what you do, because if you don't, you need to do something else.
Dina, trade-offs.
Yeah, I mean, I think Scott and Brittany kind of hit it. I don't know that I have a lot to add. Scott's right. It is a tough business. I mean, I haven't even begun to regale you with the challenges because, as small plaintiffs firms, at least in my practice, we often team up with other firms. And, I'll say when people in interviews ask me what's the toughest part of the job, I don't hesitate. I say, usually it's my co-counsel. which is unfortunate because the problem is that my adversaries, I know exactly where they're headed. My co-counsel, it's always, everybody's got a different idea and everybody thinks they're right, right? So, those are some things that are difficult. You don't have a hard-headed corporate client maybe, but man, you got some people who are pretty set in their ways, with whom you're supposed to be doing the cases together. So those are the kinds of challenges we face. For me, the trade-offs are worth it. I think I identified a bunch of them. There's less certainty. You make less money, at least at the beginning of your career, if you're a plaintiff's lawyer. The idea is that you're like Scott and Brittany and you go ring the bell a bunch of times and do a great job for your clients and make enough money to keep your lights on and keep going. And that's the hope. But it's not always clear that it's going to happen. So we take a lot of risk, but hopefully for larger rewards at some point. I can't overstate how important to me the autonomy is. My mom used to say that she had no problem with authority as long as it wasn't stupid or in the way, which I think is probably a pretty fair way to describe how I feel about it too. And so I haven't had trouble really with bosses in the past, but what I've realized is that what I have trouble with is people doing things the way they want to do them just because it's how they did it last time. That just seems like one of the most depressing ways you could possibly live your life. And as Scott says, as lawyers, we're, for better or worse, we're committing to doing what we do a whole lot of our lives. So for me, the autonomy and the ability to make decisions unencumbered by the financial interests or egotistical interests of others or whatever it is that may influence people makes a big deal. The hours, there's not work-life balance, not at my firm, not really. I think that the way we describe it is that it's low drama, but high intensity. And I mean low drama internally because I love my colleagues. And for me, the most important article of faith within the firm is that we're not jerks to each other because we have the whole world outside the firm being jerks to us or that we want to be jerks to. And so let's just, inside the family, let's treat each other with respect. And it starts with the staff. The staff is treated with the most respect. And then as I tell people are free to swear at me and tell me my ideas are stupid, but don't tell my assistant that. That is the way I think that it makes sense to run a firm. And I feel really proud that I get to, do that with my partners and with my associates. The last thing I'll say is this, is that to me, the biggest reason to do what I do is because I feel like I get to take responsibility for my own success. To put it a different way, I'm not going to be going to some job and blaming some nameless guy at the top of the chain because I'm unhappy. To me, that just doesn't seem like the way we ought to go about our lives. And so I don't mean to wax philosophical here, but it is really important because you are going to spend a lot of your time working. And if you don't find it interesting, and if you don't find the people around you inspiring, and if you don't find that you can internalize the successes in ways that you think really benefit not just yourself, but like Scott said, the rising tide where everybody does better and where you can lift up everybody, where I have the opportunity to lift up associates and all kinds of people who may not get opportunities. That to me is what work should be about. Keep body and soul together and then do something fun and interesting. So that's my take.
Sarah, anything to add on trade-offs?
I mean, I don't really see myself as giving anything up. I love my job. I do righteous work. It's really intellectually challenging. It touches people's lives in a positive way. I do get to take a lot of ownership of my work while also getting a lot of great guidance and mentorship from the partner I work for, and I make a comfortable living. So I really couldn't see myself doing anything else.
Well, good way to end that part of the class. Let me open it up to the students, and I'm going to unpin everyone so that the students can show their faces when they ask.